Hello, class and professor. This is going to be my week 3 discussion 2 post. And this week we're going to be talking about the Fifth Amendment right. The Fifth Amendment right was created by the founding fathers because they wanted to make sure everyone accused of a crime was afforded every opportunity to provide their innocence before any action was taken against them. The Fifth Amendment protects a person from being forced to reveal to the police, prosecutor, grand jury, or jury any information that might subject him or her to a criminal prosecution. The Fifth Amendment guarantees the right to a grand jury, forbids double jeopardy, and protects against self-incrimination. It also requires that the due process of law be a part of any proceeding that denies citizen life, liberty, or property, and requires the government to compensate citizens when it takes private property from public use. Basically, in simple terms, it guarantees U.S. citizens specific rights, including not having to testify against yourself if you're accused of committing a crime. Next, we have the rights of the disregard. We have the requirements of the Fifth Amendment with regards to self-incrimination. The Fifth Amendment protects pretty much everyone and keeps people from having to testify if they feel they are going to dig themselves into a hole and self-incriminate themselves. The Fifth Amendment gives you the right to refuse to make any statements which could possibly incriminate you, which includes answering questions, which leads us to the right to remain silent. The right to remain silent gives them the right to remain silent, which is basically to say nothing at all, which some may think makes you look more guilty, since silence can later be introduced into a trial as an indicator of guilt. But that still doesn't mean you're guilty. So not to answering questions about whatever they want to know is all within your rights. If you choose to remain silent, you can tell the officer your name, address, and date of birth without waiving any of your rights. In 1965, in the Griffin versus California trial, the U.S. Supreme Court ruled that the Fifth Amendment right against self-incrimination is not only allows a criminal defendant to refuse to take the witness stand during his trial, but it also bars the prosecution from urging the jury to interpret that the silence is an indication of the defendant has something to hide. The next year, actually, we saw in Miranda versus Arizona that self-incrimination is not limited to in custody testimony, but also applies when a person is taken into custody for questioning. Next, we have the Miranda rights. In order to Mirandarize someone, the subject must be in police custody under interrogation. If information is gained through the interrogation and the individual was not warned of their Miranda rights, it is admissible in court. In order to gain incriminating statements and or evidence admissible into trials, officers must make sure that it is relevant and not excluded by the rules of evidence. Next, we have motion to surpass. Motion to surpass is when a motion is filed by a criminal defense attorney when he or she has a reason to believe that evidence was illegally obtained through an unlawful search or seizure. If the motion is successful, it could lead to the state dropping charges or to a not guilty verdict in trial. Next, we will go over the remedy for motion to surpass the violation of the Fifth Amendment. An example of this would be when a suspect is not receiving their Miranda rights read to them, or if an eyewitness identification is not admissible and against the defendant if it was obtained in a violation of the defendant's due process, which could result in a risk of misidentification. Next is the attorneys on both sides have the opportunity to present legal arguments about whether the evidence should be excluded. Then the presiding judge decides on the motion. If the motion is to suppress is granted, the plaintiff may not be able to go forward with the prosecution. So basically, if a motion to suppress for a violation of the Fifth Amendment right and the judge finds that they are correct and the right was violated, then the plaintiff may get off scot-free because of the error of the police officer. And here is my reference page. Thank you.